Welcome back to episode 6 of the God Script. In our previous explainer, we paused on this massive, overarching question. Is sacred law a limit on cosmic war, or is it the rulebook? Well, the answer is, it's actually both simultaneously. And that duality exists entirely because of its divine, unamendable source. You know, when rules are handed down by the actual creator of the universe, you can't exactly just vote against them, right? That absolute authority turns sacred law into both a powerful shield that forcefully protects the innocent and a sword that commands absolute obedience.
So, here is our roadmap for today's explainer. 1. The enforcement problem. 2. Halakha and canon law. 3. Sharia, the operating system. 4. Dharma and the Vinaya. 5. Ubuntu, law that restores. And finally, 6. The limit and the weapon.
All right, let's jump right into section 1, the enforcement problem. To really grasp the power of sacred law, we first need to look at the structural spine of this entire explainer. And that's the fundamental difference between secular and sacred law. Secular law relies entirely on us, human consensus. A parliament passes a law, and if the people decide they no longer like it, it can just be amended, challenged, or voted out. Sacred law, on the other hand, comes directly from God. It cannot be voted out, it literally cannot be amended by any human institution. But naturally, that immediately creates a profound asymmetry, because if the law comes directly from God, well, who gets to interpret what it means for us today? So the crucial point is right here. Think of the estate agent analogy. Imagine a sprawling estate where the owner has written a totally binding will, but then they left the country indefinitely. So a professional estate agent is appointed to manage the property and interpret the provisions of that will. Now that agent holds unchallengeable power, purely because the owner cannot be directly consulted. In our world, professional religious interpreters act as that exact estate agent. Rabbis, bishops, ulama. Their interpretation of the divine will is binding. And the stakes are infinitely higher than your standard real estate dispute. If you challenge their interpretation, you aren't just engaging in civil disobedience. No, your challenge risks being framed as cosmic treason. It becomes blasphemy. Moving right along to section 2, Halakha and canon law. Let's look at how the Jewish and Christian traditions constructed their legal architectures to handle this exact problem. Halakha, which translates to the path of walking, operates like a living river flowing from a spring that is literally 3,000 years old. The oral Torah acts as a constitution, but crucially, it has an interpretive methodology built right into it that allows the river to pick up tributaries, debate, and adapt over millennia without ever losing its source. Canon law, however, is entirely different. Canon law functions like a massive stone cathedral. It acts as a professional licensing board that has the supreme authority to literally revoke your citizenship in the community through excommunication. It enforces natural law, which is this fascinating philosophical idea that moral instructions are built directly into the design of the human equipment, accessible to pure logic without even needing scripture. And this isn't just theory, it has massive, real-world geopolitical applications. Canon law produced the just war doctrine. Think of this doctrine as a professional operating license for military force. To deploy violence legitimately, you need to check off 6 strict conditions: just cause, right intention, legitimate authority, last resort, proportionality, and a reasonable chance of success. Now, why does this operating license actually matter? Because without it, a military campaign is not war, it is just unholy violence. This exact framework serves as the direct intellectual ancestor to our modern Geneva Conventions. But let's go back to that estate agent analogy for a second. What happens when the agent's monopoly is challenged? Well, in the 16th century, the Reformation shattered the Catholic Church's exclusive interpretive authority. Suddenly, multiple human agents were claiming the ultimate right to interpret the absent owner's will. When the ultimate enforcement problem detonates like that, the result isn't just a simple lawsuit. It is catastrophic bloodshed. An estimated 8 million lives were lost in the religious wars that tore across Europe, all as a direct consequence of a fractured interpretive monopoly. And we really don't have to look to ancient history to see the enforcement problem at work. Just look at Israel in 2026. Haredi political parties hold coalition-critical power, and their authority is derived entirely from halakhic interpretation. When they sit down at the negotiating table regarding things like military service exemptions or national marriage laws, they aren't presenting typical political preferences. They're presenting divine ultimatums. This fundamentally shifts the entire balance of power in a modern state. when earthly political negotiations are elevated to the level of divine command. Challenging the politician is viewed by their followers as a direct challenge to God.
Okay, on to Section 3, Sharia, the operating system.
Okay, let's dive into this. It's absolutely vital that we remain fiercely impartial as we look at the structure of what is arguably the most misunderstood legal framework in the world. The word Sharia literally translates to the path to water. Sharia is an operating system meant to govern every aspect of a fully human life. It is not merely a penal code. But to truly understand it, we absolutely must grasp a strict, non-negotiable distinction. Sharia is the divine constitution, the perfect, unblemished ideal. Fiqh, however, is human case law interpreting the constitution. When you see pundits or politicians furiously debating what Islamic law allows or forbids, they are almost never actually debating Sharia. They are debating fiqh, which is human, completely fallible, and heavily dependent on historical context. Now, this operating system doesn't just exist for the sake of having rules. It exists to perform 5 core functions, known as the Maqasid al-Sharia. These functions are the absolute protection of life, intellect, lineage, property, and religion. So, how does this actually apply in the real world? Well, any human ruling, any piece of fiqh that genuinely protects life or property is considered completely aligned with Sharia's core intent. Conversely, any human ruling that actively harms human intellect or breaks apart lineage is inherently suspect. To regulate daily life, Islamic law uses what is basically a 5-signal traffic system for all human acts. Wajib means an act is obligatory. Mustahab means it's recommended. Mubah is permitted. Makruh is discouraged. And haram means forbidden. Now, what is incredibly important to grasp here is that the vast majority of human action falls right into mubah, the permitted category. The slice of life that is actually forbidden is incredibly narrow. This serves as a powerful counter-narrative to the widespread public misconception that the tradition is defined solely by its prohibitions. Because of this deep distinction between divine Sharia and human fiqh, we are essentially left with 2 drastically different realities. The perfect picture of this system emerged during the Islamic Golden Age. It produced deeply sophisticated jurisprudence, immense intellectual flexibility, and minority protections that were centuries ahead of contemporary Europe. But the worst picture? That's the modern enforcement problem. In places like Afghanistan, Iran, or Saudi Arabia, a specific clerical establishment has taken their own human fiqh and weaponized it as unchallengeable divine law. They claim the complete monopoly of the estate agent, meaning any citizen who demands basic civil rights isn't just breaking a local law. They are accused of theological deviation.
All right, Section 4, Dharma and the Vinaya.
When we look eastward, the approach to authority and interpretation shifts pretty drastically. In the Hindu tradition, Dharma acts as a comprehensive operations manual for a society as a living cosmic expression. The rules, which are notably codified in texts like the Manusmriti, are inescapable because they are tied directly to the very fabric of the universe. Compare this to the Buddhist Vinaya Pitaka. The Vinaya functions purely as the bylaws of a voluntary association. Now, the rules are strict for sure, but they only apply to those who actively choose to join the monastic community. The profound difference here is that in the Vinaya, exit is always possible. But the inescapable nature of Dharma brings some deep complications. The Manusmriti contains highly sophisticated property protections, yes, but it also enforces a rigid social hierarchy, which results in the systemic exclusion of Dalits and women. The tension surrounding this text completely exploded in 1927. Dr. B.R. Ambedkar, who would later become a principal architect of India's constitution, didn't just write a polite critique. He publicly burned the Manusmriti. It was a deliberate, calculated attack on the structural enforcement problem itself. It was the ultimate physical strike against the Brahmin interpretive monopoly. But don't think Buddhism is immune to political capture. In modern contexts, we see Buddhist nationalism creating what is essentially the enforcement problem in reverse. Instead of religious clerics demanding that the government enforce their divine rules, earthly governments actually hijack the peaceful, legitimating identity of the religion to justify their own state violence. They essentially use the cloak of Buddhism without the consent of the peaceful, voluntary Vinaya. Section 5, Ubuntu, Law that Restores. Our 6th legal philosophy represents a profound paradigm shift. Think about it. Every tradition we've discussed so far rests on the basic premise of adjudicating and punishing. Ubuntu jurisprudence totally rejects that. It operates on the premise that law exists primarily to restore broken relationships. It functions like a circle around a fire, not a courtroom. We saw this incredibly powerful concept applied during the 1996 Truth and Reconciliation Commission in South Africa. Its achievement was monumental. It managed to keep a deeply traumatized and wounded community largely intact. But it does carry a severe limitation. Because it relies on distributed decision-making rather than a central text, it's highly vulnerable to narrative capture. Whoever controls the social narrative of what a right relationship means controls the restoration. So the enforcement problem doesn't disappear, it just changes shape. Finally, Section 6, the limit and the weapon. Let's bring all of this together for a grand synthesis. And this brilliantly illustrates the point. Think of the stunning stained glass of a cathedral that takes chaotic light and organizes it into a beautiful, coherent image. Religious traditions reaffirm order over chaos. The true beauty of sacred law is its limit function. It creates rules, defines procedures, and crucially protects the innocent. Across the globe, it acts as a genuine, robust limit on arbitrary violence. And that is something profoundly worth protecting. But this limit is a double-edged sword. As you've seen, every tradition we have examined built something noble to protect human dignity, but every single tradition also built a weapon. They constructed a professional class that wields unaccountable, divinely legitimated power. The rabbi, the bishop, the aliyim, the brahmin, the abbot. The mechanism is always exactly the same. Whoever controls God's rules controls everything. If sacred law defines who the community is, who does it include, and who does it exclude? That is episode 7.